another edition of Talk Law Niger. So today we're going to be talking about a very interesting topic. Now, the topic is already displaying on the screen, which is the invalidity of an unsigned contract or the validity. This is something that happens almost every day when we get involved in commercial activities. Now, what does the law say about a contract that was not signed by one of the parties? Let's get to know. Ada and Chioma, they were friends. They entered into an agreement for the sale of hair products. Now, this agreement said Ada was going to pay instrumentally with a 10% interest. After this agreement was finalized, it was documented, but only Ada signed it, while Chioma did not sign. After some time, they actually carried out business based on the terms of that agreement. After some time, Chioma failed to keep to her own part of the bargain, her own part of the contract, claiming that she did not sign the aforesaid contract. What can the law do about this? Is Ada wrong by going on with a contract that was not signed with the other party? And is Chioma free to go even after she had enjoyed benefits from the said contract that was not signed? Let's find out.
Okay, from what has been stated, it is crystal clear that it's something that happens almost every day in society. Now, first of all, what is a contract? A contract has been defined in the case of Orient Bank and Greens Bilante International as an agreement that has been entered into between parties which tells them to do particular things or to not do particular things. And then the court and her charter GSC. And then charter has gone ahead to define a contract as an agreement with the law will recognize and enforce as affecting the legal rights and obligations of the parties. There are certain things that must be present for any contract to be valid, and that ranges from the offer, acceptance, the capacity to contract, and what have you. But then we should know that these contracts can be expressed or implied. A contract is expressed where the terms of the contract are clearly stated out by the parties. It then means that the parties will come to a consensus addendum, they will meet and then define the terms that will rule and guide their contract. But where the terms are not clearly stated, or there have been a circumstance that has arisen and that has created doubt in the agreement, or that has caused distort to the clarity of the agreement, then you can say it is implied and left for the court to discover or to construe whether or not a valid contract will exist in that instance. And the court is left with just the words of the parties and with their conduct to infer whether or not a contract will exist. Now, I want you to know that Ada and Chioma entered into a contract and they wrote down the terms of the agreement, but then Chioma did not sign her part. Now, this is the exact thing that happened in the case of Metropolitan City against Railway Company, where the other party did not sign. Bludgeon against Metropolitan Railway Company, where the other party did not sign. And at the end of the contract, he said he would not keep to the contract because he did not sign his part. This is a very wrongful act, and the court has held, having regards to the conduct of the parties, what would a reasonable man say looking at the event? It is crystal clear that having followed the terms of the contract in their conduct, it means that the parties intend to be held bound by the terms of that contract. And so it is uncalled for the other party to then say that he would not be a party to the contract because he did not append his signature to a document. Now, Ada and Chioma have the same situation. Seeing that they have gone through these procedures, the terms of the contract have been kept to over time, and Chioma has been making payments instrumentally and the 10% bonus, it then means that she intends to be bound by the contract, and as such, a valid contract has been entered into between the both of them, and she cannot be held to renege from that agreement.
Okay, yes, we've heard it all. Chioma, you cannot escape from that agreement. And even there's an equitable maxim that says that the equity will not allow you to benefit from your wrong. Already, Chioma knew that she should have actually attested to or authenticated that agreement, and she did not. And yet, she went ahead to benefit. So she cannot run away since already she's into it. That means, Chioma, you must fulfill your own part of the contract. And that if she refuses to do that, you can take up the issue and institute an action against her, compelling her to do that, or you can seek for damages. That is basically what we're trying to say. So I hope you got a thing or two from today's piece. Please keep watching and keep following us, Talk Law Niger. subscribe to our YouTube channel. Have a great day.
Bye.